So Rod, with that.
Oh, thank you. I'm an old guy and I don't understand technology, and I haven't given many Zoom talks, and I was worried about this. Update is my most feared word in the English language. Holly George helped me. She said, dial in at 10:30. That way we'll have enough time to fix things if we have trouble. So I did. I dialed in at 10:30, and it said there was a meeting, a Utah historical meeting at that time, but it wouldn't let me in. I clicked all over the screen. I went out and got back in. I couldn't get in, but I had prepared. I'd asked Ms. George for her phone number. She'd given it to me. I called her phone number. No answer. I clicked out. I got back in. I was getting desperate. I sent her an email. She called back and she said, Rod, you did everything right, but your speech is tomorrow. That's why you couldn't get in. This is yesterday. So I'm very glad that I got in today and that this is working so far. Why you'd want to listen to a talk on history by a guy who can't keep the days straight is something you'll have to answer for yourselves. This talk is about 6 political disputes in Utah that started in the early 1970s, and some of them continue to this day. Here's a list of the 6. You can tell how tech savvy I am by the sophistication of my visual aids. I hope you can read that. They are birth control for teens supplied by the government without telling their parents, the Equal Rights Amendment, abortion, pornography, censoring cable television, and same-sex marriage. I have the dates here. These are in the chronological order that they came to Utah. And I have the dates here. You can see all of them lasted a long time. Some of them are still going on and lasted decades of arguing about these things. Since the 1970s in Utah, we've always had one or more of these disputes going on. We've always been arguing about them continuously since then. I'm going to argue that these 6 disputes, and there are several others that could be included in the list, are really manifestations of one fundamental disagreement between Latter-day Saints and Americans. The disagreement concerns sex, gender, morals, and families. And we don't usually in Utah politics address the fundamental disagreement, but we address it through these issues as they arise over the decades. The topic of this conversation, of this conference, is rights and responsibilities. If you look at the program, you'll see there's more about rights than about responsibilities. That's no surprise. Rights are more fun. One of the reasons rights are important and current is the American Rights Revolution. And this talk is about Utah and the American Rights Revolution. The Rights Revolution is an idea used by legal historians. They believe that starting in 1954 with Brown versus the Board, the Supreme Court decision that outlawed legally segregated public schools, starting then, judges have led an expansion of rights in America. Started with Brown versus the Board and focused on civil rights, especially for African Americans. It spread to include rights for the accused. You can see that on television almost any night. The policeman says, you have the right to remain silent. Anything you say may be used against you. It included workplace rights, rights for the disabled, voting rights. All of this affected Utah, but it didn't affect Utah any more than it affected any other American place. What did affect Utah, where Utah was special, was in the expansion of rights concerning sex, morals, and gender. Utah resisted the expansion of those rights. It resisted them probably more than any other place, systematically and with great determination. And Utah lost. Of those 6 disputes, Utah lost 5 of them, and all of the losses came in federal court. The only one Utah didn't lose yet was the Equal Rights Amendment, and that wasn't decided in federal court. Let's look at the issues. Birth control for teenagers without telling their parents. In 1972, Planned Parenthood of Utah applied for a business license in Bountiful. They wanted to open a clinic. Bountiful Mayor Morris Swap said they had to be stopped, quote, at all costs. He noted that they supplied birth control to minors without telling their parents. And he said, quote, this will lead to promiscuity and the breakup of families. 500 Bountiful citizens jammed a city council meeting and shouted against the license, and the city council people denied Planned Parenthood a license. Planned Parenthood went down the road to Clearfield, tried to open a clinic there. Clearfield went to court and got an injunction against the opening of the clinic. Planned Parenthood appealed to the Utah Supreme Court. Justice A.H. Ellett said, quote, family planning laws were not intended to make strumpets or streetwalkers of minor girls, and he decided against Planned Parenthood. Now, Planned Parenthood had been operating in Salt Lake County, several clinics, since 1970. They'd been taking federal money passed through the state grants, and they'd been serving mostly a poor, low-income clientele, including juveniles. What set off the ruckus was when they tried to move to the suburbs, which were more conservative than Salt Lake County. Having poked the hornet's nest, Planned Parenthood found itself the object of a law in the legislature. The legislature passed a law saying, if you take public money, you must get parental permission before you give birth control to a minor. Planned Parenthood took that to court, this time to federal court. They'd seen the state court. And Judge David Lewis said, the law says birth control may be given to a minor who is sexually active and who asks for it. He said, Congress intended those to be the only conditions. States can't add conditions. He was the first judge to say that, and it was adopted nationwide by federal courts. So the Utah law was struck down. Utah fought on. The legislature passed a law saying federal grants that go through the state can only go to government entities for family planning. They can't go to private entities, i.e. not to Planned Parenthood. So the state of Utah took the money, kept the money, and provided the services. Planned Parenthood went to court. The judges said, no, that's okay so long as they provide the services. But then the legislature passed another law saying you have to get parental consent. The Planned Parenthood went to court again. The court struck down that. The money was taken from the state and given back to Planned Parenthood. The state tried yet another tack. They said, if you give birth control to minors, you have to notify the parents. You don't have to get consent. You just have to tell them what you're doing. Planned Parenthood called that the squeal rule. They took it to court and judges struck it down. The legislators tried again. They weren't done yet. They said, well, we can't regulate the money coming from Congress, but we can regulate the practice of medicine in Utah. Any doctor in Utah has to get parental consent before giving birth control to a minor. Planned Parenthood took that to court. Judge said, well, you can't make a special law just for birth control. Struck it down. Then there was a special session in 1985. This had been going on for 30 years. Laws, cases, striking it down. 1985, there was a special session. a couple of hours from the end of it, Governor Bagot, a Republican, rushed up with a brand new, newly drafted bill that said for any medical procedure in Utah, if you're a doctor, you have to get parental consent before you can do it. We'll get around, we won't single out birth control. We'll say for everything you have to get consent. Legislature rushed it through and passed it in a couple of hours. Then that night, the governor got a phone call. It was a doctor. The doctor said, I get abused kids. Sometimes the parents are suspected of abusing the kid. This law would mean that I have to get permission from the parent, the suspect, before I can examine the kid. The next morning, the governor vetoed his own bill. And that was Utah's last foray into birth control for teenagers. The Equal Rights Amendment was passed by Congress in 1972 and sent to the states for ratification. Utah tried to ratify it first in 1973. Educated women, professional people generally supported it. The Church of Jesus Christ of Latter-day Saints specifically took no position, said this is indifferent to us, we're not saying anything about it. But a group of mostly women from Utah County and rural Utah formed a group called Hot Dogs, humanitarians opposed to degrading our girls. They wore little Frankfurter pins on their lapels with a hot dog and some mustard in a bun, some relish as they lobbied legislators. They had great energy and passion. They caught the educated women by surprise, and they won by big majorities in the House of Representatives, voted down ratification. Utah Democrats made ratification part of their state platform. 1974 was an election year, and it was the year after Watergate, the election after the Watergate scandal in Washington. Helped by the Watergate scandal, Democrats took control of both houses of the Utah legislature. Last time that's ever happened up till now. A poll in the Deseret News showed a slight majority of Utahns favored ratification. Looked like there was a pretty good chance for it. Then, as the legislature met, there was an editorial in the LDS Church News. That's part of the Deseret News, and it's widely considered that it's where the leadership of the Latter-day Saint Church, it speaks for them. The editorial was very mild. It didn't oppose or say the church was opposed to the Equal Rights Amendment. It said maybe it wasn't well thought through, but though very mild, it did the job. Up at the legislature, a lot of lawmakers changed their mind. Representative Byron Fisher, Republican from Salt Lake City, had been a co-sponsor of ratification, but he said, it's my church, and as a former bishop, I'm not going to vote against its wishes, close quote. He changed his mind, many others did too. Ratification failed about as badly under the Democrats as it had under the Republicans the year before. Gradually, the leadership of the Church of Jesus Christ of Latter-day Saints turned and became against the Equal Rights Amendment in several steps over a number of years. They entered the national fight. Latter-day Saints politicked against the amendment in 16 states. They had some success. They may well have been a factor in the national failure of the amendment, or at least what appeared to be the national failure. In the last few years, the amendment has been revived. If the Democrats take the next Congress, probably they will say that the amendment is part of the Constitution after all. A point I want to make about the Equal Rights Amendment is before the church leaders got in, the church women got in. They were the hot dogs up at the legislature when the church leadership was it was neutral. And the church leadership came in timidly and gradually over time after the women had had taken a stand. Abortion. Roe v. Wade was decided in January of 1973, and until then, abortion had not been much of a political issue in Utah. It was barely mentioned in the 1972 gubernatorial election, the election before. Republican Nick Strike, who was running for governor, said he would work for more liberal abortion laws in the state. Democrat Cal Rampton, who won, said he would veto any liberalization of abortion laws. As soon as the court handed down the decision in Roe v. Wade, Rampton drafted a bill and ran it upstairs to the legislature that was meeting. That bill would have effectively banned almost all abortions in Utah. The legislature quickly passed it. Judge Willis Ritter, federal judge, struck it down, quote, in its entirety, close quote. The legislature only tried one other time to make a frontal assault on abortions. That was in 1989, when they passed a law that would ban most abortions. That law was litigated for 5 years and finally struck down by federal judges. But almost every legislative session since Roe v. Wade, there have been bills concerning abortion in the legislature. They all sought to limit or curb or make abortions more difficult. They required counseling, waiting periods, showing the woman pictures, maybe ultrasounds of her fetus or other pictures. They forbade the use of public facilities or public money. They forbade, excuse me, required the father to be notified. They required parents to consent in the case of a minor, or court consent. They banned fetal research. On and on and on. The Utah Code has 38 sections on abortion. Almost all of them are these laws and that curb abortion, and a number of restrictions were struck down in federal court. In the last legislature, which ended in March, 3 anti-abortion bills were introduced. 2 of them passed, and they were some of the chief headlines out of the session. So 47 years after it started, the fight continues unabated. The first pornographic movie shown in Utah was Deep Throat. It was shown at the Gem Theater in Magna, and a number of old movie theaters, some of them shut down, reopened, a few, 4, 5, 6, maybe, almost all in Salt Lake County, and they showed triple. The police arrested the theater owners and theater employees. Prosecutors brought charges, pornography, but the first 2 juries in Salt Lake acquitted. They wouldn't convict people of pornography. In the 3rd case, Robert B. Hansen, who was Deputy State Attorney General, got the list of prospective jurors. And he saw their addresses and phoned the Latter-day Saint bishops in where they lived. And he asked them, what about these people? Are these some of us and people of proper views? He gave his information to the prosecutors, who used that information to pick a jury. Hansen was running for Attorney General for his boss's job at the time. Vern Romney was retiring, and he boasted of what he'd done on KUTV Channel 2 News. He said, based on their bishop's opinion, 5 of the jurors were sure to vote for conviction. Some of the jurors saw Hansen's post on television, and they went to the judge, said, what about this? The judge said, I don't like it, but he allowed the trial to proceed to conviction. Defense lawyers went to the Utah Supreme Court, they said this wasn't a fair trial, the jury was fixed. Justice A.H. Ellett, writing for the court, said this is a practice of all smart lawyers to research the jury pool. And in fact, lawyers do research jury pools. he said the lawyers should have inquired among, quote, pimps, prostitutes, and homosexuals to find jurors who were in favor of pornography. In the 1960s, the United States Supreme Court, in a series of cases, said sexually explicit material has First Amendment protection. And they didn't make it impossible to convict pornographers, but they made it very hard. It was legally hard to get a conviction that would stand up. Pornography boomed. In many cities, whole sections of downtown were taken over by peep shows and adult movie theaters and adult bookstores and strip shows and so forth. A lot of pornography all over. Some came to Utah, but Utah suppressed it, and Utah courts didn't do much to follow the national constitutional law. 10 cases on pornography came to the Utah Supreme Court between 1975 and 1983. The court decided against pornographers in all 10. In one of them, Justice A.H. Ellett looked at the site of the federal protections for explicit material, the First Amendment protections, and he said, it would seem, quote, such arguments ought to be advanced only by mentally deficient, mind-warped queers. Now, this is the official opinion of the Utah State Supreme Court about the United States Supreme Court. In another case, even more shocking, the Utah State Supreme Court said the First Amendment, that's the protections of freedom of speech and freedom of religion, isn't the law in the state of Utah. It caused some national comment. The University of Utah Law Review wondered if the Utah Supreme Court had abandoned the rule of law. Over a few years, the old justices on the Utah Supreme Court left, and they were replaced by other justices who had different views. In 1983, Justice Christine Durham put a footnote, a little footnote, kind of hidden in a case, and it said, we, quote, disavow those old pornography opinions. You could tell that the new Utah justices were embarrassed by them. Utah fought harder than any other state to try to censor sexy movies on cable television. In the 1970s, cable companies dug trenches and put cable in neighborhoods. Then they could, for a fee, you could get 20-odd channels, extra channels, and some of those channels showed movies uncut the way they were shown in theaters rather than censored the way they are for broadcast television. And they had channels you could subscribe to that showed softcore pornography. In 1981, the legislature passed a law banning nudity on cable TV. Federal judge struck it down right away. 1982, the legislature debated censorship, but didn't pass any laws. Citizens groups formed. They gathered signatures on petitions to force a censorship law to a vote of the people. Then in 1983, the legislature passed 2 censorship laws. Democratic Governor Scott Matheson looked at the laws. He said he got more mail and phone calls on censoring cable TV than on any other issue in his 6 years as governor. He vetoed both bills, saying they were probably unconstitutional. The legislature called itself into a veto override session. The first thing they did was caucus behind closed doors. While they caucused, the senators gave permission to a pro-censorship group to take a projector into the Senate chamber, where they showed scenes from Young Lady Chatterley and The Bitch and other movies that had, indecent movies that had shown on Utah cable television. They invited the legislators in a few at a time to see the movies. Having seen they wouldn't let anybody else in. Having seen the movies, the legislators overrode one of the vetoes. In the meantime, the citizens groups had gathered enough signatures to force a vote of the people on a stricter censorship measure. That vote was in 1984. It failed 62 to 33%, but as you can see, Latter-day Saints barely voted against it, while non-Mormons overwhelmingly against censoring cable TV. The leaders of the Church of Jesus Christ of Latter-day Saints spoke against indecency on cable TV, but they didn't mention either. They didn't say vote for the referendum. They didn't mention the referendum, and they didn't mention the legislative act. The legislative act was struck down in courts. Attorney General David Wilkinson, who was a strong advocate of censorship, and he appealed to the Supreme Court, United States Supreme Court, which was controversial because Utahns had already voted down censorship. In 1988, Wilkinson was the only Republican to lose statewide in a re-election bid. He attributed his loss largely to to his advocacy of cable TV censorship, and a lot of political observers with him. Leaders of the Church of Jesus Christ of Latter-day Saints and Utah politicians saw same-sex marriage coming a long time before it got here. They struggled, but they were unable to keep it from becoming law. In 1990, 3 couples in Hawaii, same-sex couples, tried to marry, were denied licenses, appealed. The Hawaiian Supreme Court said the Hawaiian Constitution probably requires marriage equality. They sent the case back to trial, but said the state has to come up with a very strong reason to deny the licenses. It looked as if Hawaii would accept marriage equality. The Utah legislature reacted, and in 1995, they passed America's first Defense of Marriage Act. Usually, if you marry in one state, your marriage is good everywhere. The Defense of Marriage Act said in Utah, if you have a legal same-sex marriage, say in Hawaii, it's not valid in Utah. The next year, Congress followed Utah and passed a National Defense of Marriage Act. President Bill Clinton signed it into law. In 2003, the Massachusetts Supreme Court said their state constitution required marriage equality. Utah legislators reacted to that by enacting another law saying marriage is only for one man and one woman, and then, to leave nothing undone, they proposed a constitutional amendment. The amendment to the Utah Constitution outlawed not only same-sex marriage, but civil unions for same-sex people. It went to a vote of the people. It passed, as you can see, 62 to 38%, but you could see it was divided along religious lines. Latter-day Saints voted 78% for it. Their leaders had asked them to vote for it and had asked for laws against same-sex marriage. Non-Latter-day Saints, the non-Mormons in Utah, voted 69% against it. Nonetheless, it passed. Stymied by Utah politics, 3 same-sex couples went to federal court. Judge Robert Shelby struck down Utah's laws and constitutional amendment and everything. He said the United States Constitution requires marriage equality. The first judge ever to say that. And in an unusual ruling, he refused to grant a stay of his ruling while Utah appealed. Utah went to the 10th Circuit. They wouldn't give him a stay either. Took him 16 days to get a stay finally from the United States Supreme Court. During those 16 days, 1,362 same-sex couples rushed to the courthouse and got married while they could. They jammed the hallways in the Salt Lake County Government Center. The clergymen came and married people in the hallways. The crowds cheered as couples said their vows and kissed. Seth Anderson, I think. Seth Anderson married Michael Ferguson. And then he tweeted wedding pictures. And he said, my new husband, my Mormon polygamous grandparents would be so proud. Great grandparents would be so proud, he tweeted. The appeals courts upheld Judge Shelby, and marriage equality became constitutional law in the United States. To sum up, the rights revolution changed America in a lot of ways. The way that it particularly affected Utah was in the rights concerning sex, morals, gender, and families. Utah did everything it could to resist the expansion of those rights, and Utah lost. Even the advocates of the rights revolution don't say that it was democratic. It was led by unelected federal judges appointed for life. They overruled majorities. They went around legislators. They overturned precedent. They imposed new laws on America and its people. Advocates of the rights revolution do say that it made America a better, freer, more equal society. None of the decisions by that overturned Utah laws forced anybody to do anything. You can still live in a traditional family of a married man and woman and children if that's what you want to do. But you can also become a connoisseur of pornography. You can have an abortion. You can have a same-sex marriage. And all of that's equal before the law. In some of the rights revolution, the law changed before society changed. For example, legally segregated public schools flourished in some states before Brown versus the board made them illegal, and then society changed slowly and fitfully. But in the case of the rights that affected Utah, society changed first, and judges changed the law sort of to catch up. For example, teenagers were having a lot more sex when federal judges said, all right, you can give them birth control without telling their parents. More same-sex couples were openly living in long-term committed relationships when judges said, all right, you can marry. So America had changed. Starting in the 1960s, Americans married less, cohabited more, married later, had more sex outside marriage, had fewer children, but more of those children outside of marriage. That affected families. The traditional family of a married man and woman and their children declined. From the Latter-day Saint perspective, the issue here was traditional families. As traditional families declined in America, traditional families rose in importance in Latter-day Saint preaching. Latter-day Saints lived more in traditional families than other Americans. They lived more according to the old morality that supported traditional families than did other Americans, and Latter-day Saints voted for traditional families. Since Roe v. Wade, Utah has never voted for a Democrat for president or for senator. Before Roe v. Wade, Utah was an ordinary state politically. It takes an effort of the imagination to think of that now. Utah was politically ordinary, and then it changed. And it's Latter-day Saint votes that changed it. Latter-day Saints supported the old ways, and one loss after another in federal courts led them to become strongly Republican and strongly conservative. Utah non-Mormons vote Democratic, and for the most part, they supported the expansion of rights. The rights imposed by judges changed Utah, made Utah Republican, made Utah conservative, and Utah has the most religiously polarized electorate of any state. We divide along religious lines, and we still fight over over abortion last session, but we still argue and fight over the rights revolution as it applies to sex. I'll answer questions.
Rod, thank you. Everyone, you can, and if attendees, panelists, anyone, send in your questions to Rod via the chat feature. We're monitoring that. And I'm going to start out and ask you, Rod, what perspective did your career as a political reporter give to you as you were writing this?
Well, I covered most of these things when they were before the legislature and so forth, and they were always good stories. When you're a reporter, you try to find, especially a political reporter, you try to find something that'll get you on TV. And this, everyone was interested in all of these issues. They were good for ratings. However, they weren't taken very seriously. Nobody thought they were the most important issues. But after I thought about it and studied it for a while, I thought, well, yes, they were not only the most interesting, they were the most important. They're what makes Utah distinctive. They're what explains why we're so Republican and conservative here, and why we divide along religious lines. So it wasn't like I had a revelation as a reporter or something, but that made me interested in these issues and made me think about them.
Thank you. I'm going to read a question from Kevin Falis. He says, let me just scroll up here. Says, Rod, this was great. Thank you. You mentioned that more of these conference sessions have focused on rights and not responsibilities because rights are more fun. Would you share some thoughts on responsibilities in the areas that you've talked about today? It's a great question.
Well, okay. Latter-day Saints believe that traditional families are important, and they're important because they do a better job of raising children. That may be true. For example, in 1960, 5% of American babies were born out of wedlock. In the latest numbers, 42% of American babies are born out of wedlock. Out of wedlock for babies it has some disadvantages. The chief one is you're about 5 times more likely to be poor. Poor kids have troubles. They have worse health. They do worse in school. They're more likely to be abused, more likely to get in trouble with the cops. Troubles. And Utah has the lowest percentage of babies born out of wedlock, 19%, the lowest percent of any state, has for 50 or 60 years. And Utah's child poverty rate is about 40% below the national child poverty rate, and has been since they kept statistics. So you could say, if you have a baby, you ought to be responsible for it. A responsibility. And you could say, if more people did that, then some babies would be better off. So if you want to talk about responsibilities, there's a responsibility.
Thank you. Okay, thank you for that answer. Another great question from Kevin Johnson. He says, so since as mentioned, our theme for this year is rights and responsibility. What are responsibilities in all of this? Does anyone outside of the Church of Jesus Christ of Latter-day Saints comment on whether or not the responsibilities of citizenship are affected by any of this? I am thinking of conservative historians from the past, such as the Durants, it's a great question, who would argue that morality is the basis of good society. It might add David Brooks kind of does, the New York Times columnist, but Rod?
Latter-day Saints would say morality, particularly family morality, is the basis of society. Their leaders have formally said that in a thing called the Proclamation on the Family in I think 1996. I'm not sure, 1995 or 96. 95. Thank you. And they said the family's the basis of society. Okay, people who are for the rights revolution say first, families aren't just traditional families. Families are same-sex families or couple families. Families are lone mother families. Families are blended families. There's all kinds of families, and we need to think of families more broadly than simply traditional families. And it depends on, I can only talk about this. I can't give you an answer. Traditional families have declined astonishingly over the last 50 years. Frank Furstenberg, a family sociologist, says the American family changed, and the European family too, changed more rapidly and more change in the last half of the 20th century than any other similar period in history. Families changed. Now you can say, or you'll have to decide, did society get any worse? Did society get any better? Well, some people would say, look, women have more rights, we're less racist, gay people, LGBTQ people have more rights. The rights revolution has increased liberty and equality for women and LGBTQ people. So I guess you pays your money and you takes your choice. Families have declined, but other things have improved.
Thank you. That's a measured response. Question from John Silito, who also has a session at this conference. He says, what do you think are the long-term ramifications of one-party rule for the state of Utah?
Well, it has some ramifications long-term. The chief one I'd point to is that since 1986, every single year, we have spent the least per school child of any state. I think that is primarily because Republicans have run things since then. Republicans tend to be more fiscally conservative than Democrats, and that they tend to, in Utah, certainly more anti-tax and a little less pro-education. So, and Utah schools have not had the financial support of schools in other states. Hard to say whether it's cause or effect. Utah is the state where federal land is the most controversial. Part of that is that federal land protection is enacted by Democratic administrations in Washington, and they pick on Utah, for example, in making monuments, because Utah is so Republican, they're not going to lose any votes here. Republican administrations tend to side with Utah's political establishment. So it has implications with education and with federal land. Surely there are others, but those seem to be the two main ones.
Rod, thank you. Thank you. And before our next question, I'm going to shill for the quarterly and say our spring 2020 issue is a roundtable all about public lands in the West. So in comment with your answer there. Another question, I believe from Wendy Rexatzit, asking, how do Utah's LDS voters compare with other conservative Christian faith communities on these family and moral issues? I'm wondering about both Catholics and Protestants. This is a question I would also ask.
Political scientists studied the effects of Roe v. Wade on voting, and that the effects were considerable. The chief one was that conservative religions, Latter-day Saints, evangelicals are the big one, Pentecostals, all became strongly Republican. Before Roe v. Wade, Latter-day Saints were tended Republican for a few years before, but over time they had divided between both parties since statehood. Evangelicals weren't very political before Roe v. Wade. All of them became strongly Republican and strongly conservative. People without religion nowadays, the more religious you are, independent of faith, the more religious you are, the more often you go to church, the more likely you are to vote Republican. People who don't go to church very often are more likely to vote Democratic. So there's a religious element in American voting, and it's come partly, at least, from the rights revolution concerning sex and morals.
Thank you. Well, here's a hot question from Kevin Phalis asking any comments on the rights to wear or not wear a mask during the current pandemic?
No, that doesn't seem to be. No, you could.
Okay.
I'm not wearing a mask, but I don't think it could sneak through the TV.
I hope not. Okay. A question we talked about before recording. What other case studies or issues could you have brought into this presentation today?
There have been other issues that you could include in this group. Okay, a big one is gay clubs in public schools. They formed gay-straight alliances, they were called, and Utah passed laws against them. And over time and fighting, and it's a story like the stories I told, it ended with a federal judge striking those laws down. Gay adoption, that never went to court, I don't think. I'm pretty sure it never went to court standalone. It had been decided in Florida that states could pass laws against gay adoption. Utah passed such a law, but it fell when same-sex marriage became the law of the land, because now that their marriage is the same as any other marriage, so they can adopt the same as any other married couple. Sex education in schools. In the 70s, 80s, and 90s, teenage pregnancy rose enormously in the United States, and it scared people. And people argued about what to do. The standard answer nationwide was sex education in schools, particularly tell the kids, if you're going to have sex, use birth control. Utah opposed that, passed laws against it, said you can have sex education, you just can't talk much about sex and not about, you have to tell them don't do it, and you can't talk about birth control. And some people said, look, Utah will have high teen pregnancy, but in fact, Utah teen pregnancy was significantly, about 40% below the national average. But that never went to federal court. The federal courts don't claim jurisdiction over what's taught in schools. So those would be the three major ones I'd point to.
Okay. I think we're going to wrap up pretty soon here. Do we have any more questions from the audience you'd like to ask? Okay. One question we talked about beforehand about what evidence do you see that it's the family issues rather than, say, states' rights or economic issues, other aspects of politics that's driving Utah, I guess, rightward? Okay.
One's when it happened. Utah, I said, used to be ordinary. From statehood in 1896 through 1972, there were 20 presidential elections. Utah voted for the winner in 17 of them. Only 3 states voted for more winners in those 20 elections. Utah swung with America. In 76, for the first time ever, Utah was the state most strongly for one candidate. It was most strongly for Gerald Ford, Republican, and it's been the most Republican state in 7 of the subsequent 11 presidential elections. It happened after Roe v. Wade. The political scientists, as I said, studied Roe v. Wade and showed that among evangelicals, it was a major factor in making them Republicans. There weren't any studies on Latter-day Saints, but I assume they were the same. It was especially important in Utah because nationally, evangelicals, Latter-day Saints, conservative religious people were about 25% of the electorate. But in Utah, Latter-day Saints are 2/3 of voters. So what was a major change in America was an overwhelming change in Utah, and one that still determines Utah politics.
All right. Well, Rod, thank you. Thank you to our audience. You have, Rod, just a great fund of knowledge, and I appreciate you sharing it with us. So to everyone in the audience, our panelists, thank you. Chris Hansen from the State Historic Preservation Office, thanks for running the tech. And we will continue to have sessions throughout the month of September, some of them live, some of them pre-recorded. So with that, Mr. Decker, thank you. And
Thank you very much. I had fun.
All right, take care. Bye-bye.
Bye.